Hello everyone, welcome to Legacy Academy. Yesterday, Supreme Court delivered a very landmark judgment about the economically weaker sections of the society. So, in this video, we will look at what is this economically weaker sections of the society, and at the end of the video, we will be looking at what is the conclusion that we can draw from this judgment. So, coming to the context, you can see here Supreme Court in a majority judgment. Actually, it was a five-member judgment, five-member bench, out of which the three people said that the EWS reservation is not unconstitutional, and two judges of the Supreme Court were of the opinion, including the Chief Justice of India, which was a minority judgment. Okay, those two judges were of the opinion that the EWS reservation is a breach of the basic structure of the constitution. Okay, so Supreme Court in a majority judgment upholds the EWS quota. See, we have been hearing a lot about what is this EWS quota. What is this EWS? Economically weaker sections of the society. How did it start? Where did it start from? See, first thing happened in the year 2019 when the central government came out with something called as 103rd Constitutional Amendment Act. According to this Constitutional Amendment Act, in the fundamental rights, two articles were amended, that is Article 15 and Article 16. Remember, Article 14 to Article 18 revolves around right to equality. So, Article 15 and Article 16, the sub clauses were amended, and the economically weaker sections were provided reservation in education and employment. The amendment had changed the constitution and introduced a quota for the poor among the so called forward castes. Remember, from 1991, that is after the implementation of the Mandal Commission report, the OBC, that is other backward classes, were enjoying the reservation of 27%. And we all know that the scheduled caste and the scheduled tribes will also have the reservation. So this EWS quota was restricted only to those people who do not enjoy any kind of reservation based on the caste. So the EWS quota was completely economical and not social. Remember this, and we will have to use this in order to analyze this particular judgment in the few minutes. So remember, as this concept of reservation, the concept of reservation itself, you will be studying in the GS1 under society, that reservation is not an anti-poverty measure. This is what something that we had studied. But here the Supreme Court has said that reservation is an anti-poverty measure. Reservation can be economical in nature, can be based on the economic criteria. So this is something that we'll have to update in the answers that we'll be writing in the next mains or your essay. So this amendment, that is 103rd Constitutional Amendment, which provides reservation to the economically weaker sections of the upper castes, was challenged in the Supreme Court. See, we have a mechanism in our Supreme Court that the law that is passed by the parliament can be challenged in the Supreme Court, and we'll be talking about what is this in few time. So remember this: what is this EWS? What does the government say about this economically weaker sections? You can see here the EWS certificate has to be got, and in order to get this certificate, these are some of the conditions that a candidate has to possess in order to get the advantages of the economically weaker sections. He should not belong to the scheduled caste, scheduled tribe, or the other backward classes. He should not be a part of this because these people belonging to these categories are already enjoying the benefits of reservation. The family's gross income should not be more than 8 lakhs, and these are some of the provisions with respect to the property that the household can have. So, if any candidate fulfills all these criteria, we know the advantages in the form of reservation, that is 10% reservation in the employment and education. This is what the EWS or the economically weaker section means. See, I've told you that 103rd Constitutional Amendment was challenged in the Supreme Court. When we're talking about the judicial jurisprudence, two key words in the polity that you would have studied already. One is called as procedure established by the law, and the other one is called as due process of law. See, the procedure established by the law just sees if the law that is passed or a bill that is passed, that becomes an act. If that act was when the bill was being passed, were all the conditions met? If at all, it has to be passed by two-third majority. Was it passed by two-third majority or not? Or if it had to be passed by simple majority, was it passed by the simple majority or not? So the rules will be checked in the due process, so in the procedure established by the law. But over a period of time, due to various judicial pronouncements, India has every now and then said that India follows due process of law, where any law passed by the parliament is checked for its just and the fair nature, and the law should not violate any basic structure of the constitution. So in the comment box, I want you to comment that where did we get this basic structure of the constitution. We have something called as basic structure of the constitution. So where did we get it from? Did we get it from the constitution? Did we get it from any of the act that was passed by parliament, or did we get it from the judiciary or any judicial or any supreme court judgments? So I want you to comment this in the comment box. So this is called as the process of judicial review, a very important keyword. Remember this. What is judicial review? The intervention by the judiciary for an act passed by the parliament in order to make sure that the act is fair or just, and doesn't violate the basic structure of the constitution or the fundamental rights, is called as judicial review. So along because of this provision, 103rd Constitutional Amendment Act that was passed by the parliament was moved to the Supreme Court. And now Supreme Court, that is 5-judge constitutional bench of the Supreme Court, has given a final verdict and said that this amendment will not violate any of the basic structure. This amendment will not violate any fundamental rights of any Indian citizen, and this amendment is very much constitutional. And the EWS reservation of 10% is here to stay. The challenge was based on the argument that the 103rd Amendment violated the basic structure of the Constitution, and the Supreme Court came up with the majority judgment, that is 3:2, and said that this is not unconstitutional. And what did the judgment say? So, as I told you that this is a 3:2 judgment, that three judges were favorable to the 103rd Constitutional Amendment, and 2 judges were dissenting on it. Okay. So, the dissenting judges judgment by the CJI. The CJI, the Chief Justice of India, UU Lalit, the CJI, he was one of these dissenting judgments. See, this is not something that is very common with respect to Supreme Court. Okay, so most of the cases, the CJI will be a part of the majority judgment. This is one of that peculiar case where the CJI is a part of the minority judgment. So he said, he along with Justice Bhatt, one of the opinion, that the economic criteria introduced in the 103rd Constitutional Amendment violates the basic structure of the Constitution, and also the first provision of the EWS that says a person who has to qualify for this reservation should not be belonging to SC, ST or OBC. Even that is discriminatory, and this violates the basic structure of the Constitution. This is what the Justice Bhatt had to say. And UU Lalit said he completely agrees with the opinion of the Justice Bhatt. So there were few important questions that were asked by the Supreme Court judges during the process of the jurisprudence of this 103rd Constitutional Amendment Act. First one, can there be quotas based on economic criteria alone? So the majority judges, 3 judges said, of course, yes. And by answering this question, the 3 judges said that 103rd Constitutional Amendment is constitutional and it is valid. Is exclusion of the SC ST quota discretionary or discriminatory? Exclusion of SC and STs and the OBCs from the 103rd Constitutional Amendment Act, is it discriminatory? It said no, it is not discriminatory, because the SC, ST and the OBCs or SEBCs, they already have 50% quota. So when they already have 50% quota, excluding them from the economical criteria is not discriminatory. Can the quota for poor breach 50% ceiling for the reservation? See, according to the Indra Sahani judgment, the Supreme Court had put a cap on the maximum percentage of reservation, that is 50%. So any reservation cannot exceed 50%. But the Supreme Court in this particular judgment said, yes, of course there is a cap of 50%, but during the unavoidable circumstances, during the very special cases, this can be breached, and EWS reservation is one such special case. So what is the conclusion that we can derive out of this particular judgment? See, one thing I've told you already, that poverty was considered not as an anti-poverty measure. Sorry, the reservation was considered not as an anti-poverty measure, but by 103rd Constitutional Amendment Act, which was considered constitutional by the Supreme Court, the Supreme Court made sure that the reservation can be purely based on the economic criteria, purely based on the economic criteria. And also, Supreme Court came up with one more opinion and said, see, reservation is a concept to make sure that there is an equality in the society. And when we talk about the economic inequality also in India, which is huge, so in order to make sure that economic inequality and the inclusive growth is achieved, the reservation based on purely on the economic criteria is valid. So these are the two conclusions that we can draw from the judgment given by the Supreme Court. If you have liked the video, please share it amongst your friends, comment in the comment box, and like if you have liked the video. So for more such enriching content, please subscribe to Legacy Eyes Academy. Have a nice day. Thank you.